Welcome to the Family Law Frontline.
Welcome back to the Family Law Frontline with Fedor Kozlov. Fedor is the founding partner and chief litigator at the law office of Fedor Kozlov, PC. With over a decade of experience in Illinois family law, he handles high-stake cases involving custody, property division, domestic violence, and complex divorces. I'm Leanne Lyon, and today we are talking about what happens when grandparents or other relatives step in to care for children and need the court's help to make it official. Fedor, what kind of family situations usually lead to grandparents or relatives seeking custody or guardianship of a child?
Well, there can be several circumstances. So the grandparents can seek a custody of a grandson or granddaughter, for example, only in the case when their child, the biological father or the mother of the child, either deceased or incapable of taking care of the child, which could be if they're in jail, if they're in rehab, there's a drug problem, alcohol problem, things like that. The grandparents also can be awarded a custody of a child, their own child, not a grandson, not a granddaughter, also for the same reasons when the child is disabled or there are other things in place, such as also as drug abuse and so on and so forth. Another case can come up when grandparents become foster parents for a grandson or granddaughter in cases when DCFS is involved, Department of Children and Family Services, when there is an allegation of abuse of a child.
So when someone who isn't a parent wants custody in Illinois, what does the law require before the court will even hear their petition?
You have to be related to the child or children. You have to be, preferably if you're related by blood, or you have to be some kind of close relative for the children in order to get the custody of the child. The other thing is, of course, consent of the other parent. So, if we're talking about children that do not have parents, let's say tragedy happened and they don't have mother and father anymore, then grandparents can step in and of course have a custody of the child. If there is a live person who is a biological mother or the father, you have to have their consent, or you have to be able to prove that they are unable or unfit to take care of the child. You also have to go through Department of Children and Family Services and be approved. They have to come out and investigate your property, investigate your household, where the children's going to live, if there is, the place for them to sleep, place for them to eat, things like that. If a person who seeks custody and not as a parent of a child, it would also help if such person has kids or had experience dealing with kids, things of that nature.
Sure. Have you seen cases where grandparents actually have been raising a child, maybe even for years, without formal orders? And what challenges do they face when they finally ask the court to recognize that arrangement?
Yes. We had a case, several cases actually, but one specifically comes up in my mind when grandparents were filed for custody, and at the beginning they filed for the parenting time, and that's another aspect of this. Like, we have to understand that, first of all, we have to take in consideration the age of a child. If we're talking about someone who is 2 or 3 years of age, completely different procedure versus somebody who is 10, 15 years of age, a teenager. That's number one. Number two, usually with cases like that, you have to have appointed a child representative or guardian ad litem. Such person, it's an attorney who will represent the best interests of the child. So before someone such as grandparents, in my case, would get opportunity to have the full custody of the child, it has to be, you got to get to that point. For that, you have to gradually increase parenting time, visitation time, things like that with a particular child. So in that case, it was a daughter. She was a girl. She was 7 years of age. Her father died from an overdose, and I represented the parents of the father. The mother of the child was in and out from rehab clinics, and the child lived with a foster parent that had nothing to do with the family. That case was Those cases especially difficult because we all talk about what's in the best interest of children, and once the child is placed with a particular family, such a foster parent, and if everything goes right, then the DCFS or juvenile judge very much reluctant to remove the child from that circumstance and place in a different circumstance, even though it's a grandparents who are related by blood, but the child already used to have this particular family. Now, the interesting thing about the foster parents, they have to comply with all the DCFS orders, and they can refuse to have the child at any point of time with a proper notice. So in that case, why the grandparents stepped in, because the mom was not capable of taking care of the child. There was no family on her side. The father is deceased, and the foster parent refused to take care of the child. Even then, the grandparents were given some visitation time, and then at some point, the child was removed to their household, and they got a full custody.
So, how does the court decide whether a parent is unfit or unavailable, and how high is that standard to meet?
It's a very high standard.
Mm.
The biological parent is always extremely important in the life of a child. And then, in the very rare cases that I've seen, I think so far only two, when the parent decides uh, when parent decides to remove himself or herself from the life of the child and uh, waive any parenting rights towards the child, the court is very reluctant to do that. Even the parent says himself, "I don't want to be responsible for this child anymore. I don't want to be his father or his mother." So for the court to decide, you have to go through several evaluations for the parent. So there's several different motions has to be filed. The parent has to be analyzed, evaluated, and then once a definite conclusion that the parent is not capable of seeing the child is made, then the court can make a decision. A lot depends on the recommendation that is made by the guardian ad litem. And I mentioned two phrases before. I said a child representative or a guardian ad litem. So these are two different roles that attorneys might have. A guardian ad litem, they call it eyes of the court. They can only do a recommendation. So that's all they do. They cannot file a motion. Their communications with the child is not protected by attorney-client privilege, and all they do they just recommend and say this particular parent is unfit. It's not in the best interest of this child. This parent remains his father, something like that. Uh, the child representative is an official attorney for the child. Such person can file motions. Such person can not be questioned by anybody, and any communication between child representative and the child is protected by attorney-client privilege. And that person, child representative, can petition the court uh, for a specific relief and ask for a specific appointment of either foster parent or remove the custody or other things that they can do. So a lot depends on those attorneys who represent the child in order to evaluate if a parent is a fit person.
So, what rights do biological parents keep when somebody else is granted custody or guardianship? And can those rights ever be restored later?
It could be, it's very difficult to do. So you do keep some kind of rights. For example, right to see your child, right of visitation. And then when we go through these courts, and then I remember this one other case when the mother was removed of her rights to be the mother of the daughter, because she survived, but she overdosed on drugs. Well, the daughter was 1 year of age or something like that, and so the court removed the custody from her and gave it to her father. What's interesting in that case that the daughter they all lived in the same household, but the custody was given to the father, to the grandfather. Later, she tried to get the custody to herself, but the court said that the effort that she showed were not enough. So you have not only you have to show in that case she had to show that she doesn't have any drug abuse anymore or use alcohol. You have to go through constant um, tests, and you have to show that you have stable employment, that you have a stable environment, that you can provide for your own place to live and things of that nature. So she still has the right, obviously, to see the child. She just didn't have the right to make decisions on behalf of the child. She wanted to, but she couldn't. Um, Even though you, as a parent, as a biological parent, could potentially lose the custody or the rights for the child, the parent still has obligations towards the child. So, for example, you might not be relieved from the burden of paying child support, so you still have to pay child support, and the court very strict on that. The judges usually say you created the life and you're responsible for this life no matter what. You don't want to make decisions for this child, but if you're employed, you have to pay child support. If you're not employed, you have to explain to court why you're not employed. Are you employed voluntarily sitting at home? Or maybe there's a medical reason. So it depends. So just because you lose rights, the obligations stay.
Got it. So, as we're wrapping up here, and this is for relatives caring for children right now without a court order, what's the most practical step that they can take to protect the child and themselves legally?
Without the court order, it's hard to say. For the parents, it happens a lot. When especially grandparents taking care of the children while parents at work or whatever the situation can be. You have, like, in the case that I pretty much had yesterday, the judge said if you not a party to this lawsuit, you pretty much do not have rights. So at the very least, if there's anything in court that is currently pending or was filed before, or whatever it is, or if you need to start a new case, you have to be a party to the lawsuit. So you need to file what's called appearance. Appearance is a form that you file and that you say that I want to be a part of this lawsuit. You pay the money to the clerk of the court. And this way, if appearance is granted, you get notifications, you get the court orders, and you have a right to say something in court. And once you have that, you need to work with your lawyer in order to make sure that the court order is in your favor. And this way you can protect your rights.
Are there ever cases where a non blood relative can get custody of a child, say of a godchild in some cultures, or a close friend? Is that just really, really never happen?
No, you can, but then you have to become a foster parent. So you have to go through the administrative procedure with DCFS. One of the things that one of the requirements. So if you have trouble with one of the parents, you have to distance yourself from that parent. So if you close relative, a godmother, godfather, very close friend, that biological father or mother cannot be on your property or cannot receive mail at your address. You cannot communicate. You cannot have the child pretty much going to them. So you have to prove to the court that you are close to the family. Knew this child from before. You are fit and proper person to have a custody of this child, but also you distance yourself from that trouble that whoever that put in trouble this child in the first place.
Got it. Well, thank you. And that's it for today's episode of the Family Law Frontline. If you are a grandparent or relative caring for a child and need to understand your legal options, visit lawyer-il.com to connect with Fedor Kozlov and his team. Thanks for listening, and remember to like, subscribe, and leave a review if you found this episode helpful. Thank you, Fedor.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.